My name is Diana Wallis. I'm a member of the European Parliament for Yorkshire and the Humber region, and I've been here in the European Parliament now for 12 and a half years. And in that capacity, the main policy committee that I have always worked on has been to do with legal affairs, and particularly with issues of civil and commercial law. And what I'm going to do is give an overview of where we have sort of come from in terms of the civil law agenda and where I think we are going to in the next few years. First of all, I would like to go back to 1999, which happens to be the year when I was elected, but also was the year of the so-called Tampere conclusions, council conclusions that decided in the area of civil law that we should have an area of justice, freedom and security. And that was an important starting point. And at that time, when I entered the Parliament, there were a whole number of issues that looked as though the whole civil law agenda was really coming to life, particularly up until then in terms of dealing with which court had jurisdiction or how judgments could be enforced across Europe. You had to deal with the Brussels Convention. Now, a convention is an intergovernmental agreement. But at that time, we changed it from a convention into a regulation. A rule of private international law became Europeanized, became a European regulation, meaning that the cross-border enforcement of judgments and the issues of jurisdiction became much similar. Likewise, Rome II, the new regulation that dealt with the issue of whose law in terms of non-contractual obligations. That means the law of tort. That again was a big departure. We also dealt with a whole agenda to do with trying to simplify trade, to do with the new media of e-commerce and the synergy of e-commerce with the internal market, how to make consumers more confident, with the beginnings of an ADR system. Now, much of that perhaps came from the fact that in those days our committee structure in the European Parliament was founded on a legal affairs and internal market committee, which brought together those two activities in a very clear way. In other words, it meant that our civil and commercial regulation was very much targeted or directed at making the internal market work. And in this sense, structures in political arenas can matter, can make a difference. But what can also make a difference are events. And none of us could have forecast what the impact of 9/11 would have been on the justice agenda. Suddenly, security issues took the primary role. They dominated the whole justice agenda in Europe, the whole war against terror. And this meant that many of the civil and commercial law issues took for many years something of a back seat in our legislative agenda. But now the scene has changed again, 10, 12 years on, and we find ourselves in the midst of a terrible economic crisis. By some commentators' standards, perhaps the worst we have seen since the 1930s. And so the whole nature of what we do, and indeed our debate about Europe and how far the European Union can intervene in the area of civil justice, has changed. I would say that there are two clear themes as we go forward. One of those is justice for growth, which clearly again links justice legislation to the internal market. And the other is the European Year of the Citizen, which has been designated for 2013, how we make a reality of freedom of movement. Again, personalities can be important. We have a new Commissioner for Justice and Human Rights, Commissioner Reding. She's an experienced Commissioner, having already served previous terms and indeed been a member of the Parliament. It was interesting that she came to her hearing brandishing a copy of the draft common frame of reference on contract law, something many of her colleagues would have been too scared to do. But she has been willing to pick up many of the pieces of the civil justice agenda and find a way of taking them forward and linking them to our current problems and difficulties and the way we might solve them. So we are now faced with a flurry of activity in the civil justice area, both in terms of what we are doing now and what is coming down the tracks at us. Back again to Brussels 1. That centrepiece in relation to jurisdiction and judgments. Now, 12 years on, it's being reviewed, recast, with a view to totally doing away with the exequatur process. That means no need for any second process in the member state of enforcement of a judgment. We think we've got to the stage where mutual recognition between member states' justice systems is such that we can really trust them and we don't have to go through a second system. So much simpler recognition of judgments. On the same theme, in order to make sure that we get better cross-border enforcement of judgments, there are issues to do with preservation of debtors' assets in terms of charging bank accounts and identification of debtors' assets. This too is new territory, but all goes in the same direction, that if companies and small businesses do trade across borders, there are methods there to make sure that they can get access to justice and they can get judgments paid. Likewise, we are really looking at a groundbreaking way of trying to unlock the market's potential. We've been talking for years about European contract law and coherence in European contract law, the DCFR, the CFR, and how we get better contract law. Now at last we have a Commissioner who has been brave enough to put a proposal on the table. A proposal for an optional instrument in European sales law. This has the potential to allow parties from two jurisdictions to sign up on the same terms and conditions and know what they are saying in one another's languages. It could be a real win-win situation, enabling and facilitating cross-border contractual regulations and giving confidence to SMEs and consumers to enter the European market. So really realising the full potential. That, together with new systems of ADR and online dispute resolution, particularly in the consumer field, so that we really have no fear of entering Europe's market, of buying on the internet, of buying cross-border. The other piece of the puzzle, and long missing, was to allow to European citizens the possibility of making claims together when they have the same cause of action, so-called collective redress. And now again we seem to be really moving, looking at the possibility of establishing a legal framework across Europe to provide us with a system of collective redress. And note that I say collective redress, not a class action. This is not going to be a US system. This is something that will respect Europe's legal culture and heritage, something that Europeans can be proud of, giving greater access to justice and really promoting competition in the internal market. Then there is the whole agenda for our citizens, really making sure that they feel happy to exercise freedom of movement, to move, to find work, to take their families with them. How do we make this easier? Well, we could make it a lot easier for starters by mutual recognition of civil status documents. We expect proposals on this. Also doing away with some of the legalisation formalities when legal documents have to be recognised cross-border. Really making a reality of it being much easier to move about Europe, to study, to work, to retire with a minimum of legal hassle. Likewise our work on successions and inheritance. But there is no point us sitting here and producing loads and loads of legislation if we haven't got the judges and legal personnel in all of our countries who understand this European legislation and regime and are able to properly use it and enforce it. Therefore, in tandem, there is a huge push, which is now allowed through the Lisbon Treaty, to really encourage the training of European judiciary and other personnel, making sure that national judges who are at the coalface of using European law understand it and feel confident in using it and applying it. Nothing could be more important to make Europe's justice system really work. And there again, there should also be access to every individual that seeks information about Europe's justice system. The new e-justice portal makes it possible, for instance, for any citizen to log on and find a lawyer wherever they need a lawyer across the EU. But not only that, much more information about Europe's legal systems, how they work, and what you need to be an active, mobile citizen or business across Europe. So that's the civil justice agenda for now. There's a lot on it. It's exciting. It is about justice for growth. It is about a Europe for Europe's citizens that really allows them to live out to the full the offer of freedom of movement. Thank you.